Hey guys, Matt LaRosiere here with Firearms Policy Coalition, bringing you another weekly update just to make sure you have all of the latest information on everything affecting your right to keep and bear arms. First up, we have some really interesting news on a subject that's really near and dear to me, as well as relevant to this shirt. Defense Distributed gets its day in court. We got great news from the Federal Fifth Circuit Court of Appeals related to the case Defense Distributed versus Gruel, which is a case about the First Amendment and 3D firearm files. This case has been dragging on for a while because Gruel, the defendant, is Attorney General for the state of New Jersey. Gruel, you see, decided to take it upon himself to bully gov't in Texas into refraining from publishing files online and other constitutionally protected speech activities. So gov't sued, and Gruel contested the court's jurisdiction over him in the lower court. For some reason, the lower court bought it, and they dismissed the case against him, which led to this appeal. Turns out the lower court got it wrong. They do have jurisdiction over Mr. Gruel, which means gov't may finally get its day in trial court. What's most ironic here is that Gruel himself was involved in a suit to prevent the federal government from settling with gov't, again in Texas, by suing him in Washington state. So I guess we're allowed to get creative with jurisdiction when it meets our political needs, but not when we intentionally violate the rights of others. Speaking of Washington state, court to hear age-based gun ban case. In Washington, there's a case where the plaintiffs are challenging the state's initiative I-1639, which we've talked a lot about. It prevents legal adults under the age of 21 from obtaining semi-automatic rifles, among other things. Now think about how ridiculous that sounds. The same state that's home to military bases like Whidbey Island doesn't believe that people old enough to serve their country should be allowed to buy the civilian version of the rifle they might defend it with. The state's argument is, of course, that the ban reduces the probability of mass shootings. But the odds of being murdered in a mass shooting are about 1 in 11.6 million. So it's kind of ludicrous, especially to the great extent it infringes on the rights of adults. The judge appears to be pretty neutral on the issue, but he did tell plaintiffs that it looks like they have an uphill battle. We wish them all the best. PSA's Californiaoopsie. It seems there was a communications problem between Palmetto State Armory and their clients. Specifically, they accidentally shared the contact information of all the people who tried to order standard capacity magazines after the Ninth Circuit declared the California magazine restriction law unconstitutional. Basically, they sent out an email to all Californians who had tried to buy a mag, but instead of BCCing them, they CC'd them, meaning everyone on the list could see everyone else on the list. Whoops. Now this is kind of a big deal because it could create a list of people who tried to do this, and there's no telling how easily it could slip into evil-doing government hands. Now, over on the East Coast, New York legislators are at it again. It seems that New York legislators are up to no good. State Senator Zeltnor Miri, who represents Brooklyn, wants to pass a state law that would hold gun companies liable for harm caused by criminals. This is something that the PLCAA, the Protection of Lawful Commerce in Arms Act, was intended to prevent. It also reflects the basic principles of products liability. Think about it. It doesn't make sense to sue a car company when one of their vehicles is used to commit a vehicular homicide. That is a misuse of the product. So why should a gun company have to pay when someone commits a similar criminal act? The point of this law is to make it financially impractical to manufacture or sell firearms, which would have a devastating effect on the availability of firearms, something we're seeing enough of as it is now. Another Right Honorable Brooklynite, Assemblyman Felix Ortiz, wants to pass a bill requiring all gun owners to carry at least $250,000 worth of insurance. And that's kind of ironic considering New York previously banned the NRA's Carry Guard insurance plans. Now, just like the products liability defamation being pitched by Miri, the point of this one is clearly to make it cost prohibitive for working class people to exercise their right to keep and bear arms. Fortunately, there's some good news about New York City. Rob, who goes by 2A Updates on Twitter, was kind enough to compile a spreadsheet of state and federal court cases related to the NYPD gun licensing division. So if you'd like to know more about how crooked that process is, check out his Twitter page or our news site for the link. Now in Chicago, state legislator may sue Chicago over civil rights violation. In Chicago, a state legislator is deciding whether he should sue the city after he was wrongfully arrested for his lawful gun possession. After he was pulled over for a busted headlight, it's always a freaking busted headlight, State Representative Curtis Tarver was asked whether he had a firearm in his vehicle. Tarver informed the police that he did have one out of an abundance of caution. Well, the police then ran his firearm owner ID card, and the system said it was expired, which is kind of irrelevant because the Illinois State Police said they would honor expired IDs during the COVID pandemic, as it's almost impossible to get them renewed right now. Even so, the officer cuffed him tightly, keeping him from using the restroom for 7 hours, which is kind of rude, if you ask me. Now, the prosecutor has dropped the charges against Representative Tarver, as they should have never been filed in the beginning, but Tarver is reportedly mulling over filing a lawsuit. Now, personally, I think these types of abuses need consequences. We'll see. Back to the East Coast, North Carolina cops upset over search consent forms. In Greensboro, North Carolina, the police are up in arms thanks to a new rule by the city which requires them to obtain written consent to conduct searches. Hilariously enough, the attorney for the city's Police Officers Association claimed that requiring the police to obtain this consent will increase crime and endanger the community. Look, if the search is consensual, what's wrong with having them sign a consent agreement? I mean, it couldn't possibly be that many of those old consensual searches were actually coerced, could it? I don't know, but we'll see what happens. Last but not least, some news from our neighbors in the north. Canadians taking buyback bids. It seems the Canadian government is courting 15 companies in an attempt to find one to design the country's buyback initiative, a result of Justin Trudeau's unilateral decision to suspend the rights of residents to bear arms after a single criminal event. 15 companies. That's 15 companies willing to compromise the civil rights of Canadians and other residents, and a government trying to pawn that off to boot. I hate seeing our frosty brothers get abused, so we'll be watching. Well, that's all I've got for you this week. Thanks for tuning in. If you'd like to know more, check out fpcnews.org, where you can find this week's edition and information on all of our legal and legislative efforts. If you think this content would be important to anyone you know, help us spread the words and tag them in the comment. Also, be sure to check out fpcgear.com, where you can get all kinds of Pro 2A gear like this shirt and the flag. Help keep us in the fight. As always, keep your eyes on Firearms Policy Coalition, where we're keeping up the fight for all of your rights all the time. I've been Matt LaRosiere, and I'll see you real soon.